Hello everyone, welcome back to our pre-review class for the corporation law. Now for this video, we will discuss about other corporations. Now let's start with closed corporations. A closed corporation within the meaning of this code is one whose articles of incorporation provides that all the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record, but not more than a specified number of persons not exceeding 20. So kung ang inyong korporasyon ay yung shares niya ay held of record by not more than 20 persons, then that is a closed corporation. All the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. So, if meron siyang restrictions on transfer, then that is a closed corporation. Because yung open na mga corporations, open sila to the public, no? Walang restriction na sa transfer. So kung ikaw ay stockholder, gusto mo ibenta yung shares mo, makakabenta ka kaagad, no? Walang magagawa yung corporation. I-report lang yung yung pagbenta ng shares para mabago yung name doon sa libro ng corporation. But for closed corporations, dahil closed siya, meaning restricted siya to selected persons or specified number of persons, then meron siyang mga restrictions on transfer. Okay? The corporation shall not list in any stock exchange or make any public offering of its stocks of any class. So hindi siya open to the public yung kanilang stocks. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock or voting rights is owned or controlled by another corporation, which is not a closed corporation, the meaning of this code. So meaning to say, di ba sabi natin, kapag not more than 20 persons yung shareholders ng corporation and mayroong restrictions on transfer at hindi siya open to the public, closed corporation siya. Pero paano ngayon kung isa sa mga stockholders ng corporation is also a corporation, but a corporation which is not a closed corporation? So, paano natin i-determine ngayon ang nature ng corporation? Closed ba siya or open? So, tingnan natin kung sino ang nagmamay-ari ng 2/3 ng voting stock or voting rights. If it is controlled or owned by another corporation which is not a closed corporation, then the corporation is not to be deemed a closed corporation. It is a public corporation or open corporation. So any corporation may be incorporated as a closed corporation except mining or oil companies, stock exchanges, banks, insurance companies, public utilities, education institutions, and corporations declared to be vested with public interest in accordance with the provisions of this code. So bakit ba na itong mga corporations na to hindi pwedeng close? Kasi these kinds of corporations are vested with public interest. Dapat open talaga siya to the public. So therefore, bawal siya na maggawa ka ng closed corporation tapos ito yung mga klase ng mga corporations na i-form or i-organize mo. Okay, take note of that. Now let's talk about educational corporations. No? They are primarily governed by special laws and the general provisions of the corporation code. Okay, religious corporations. We have corporation sole for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. A corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. Religious societies. Unless forbidden by competent authority, the Constitution, pertinent rules, regulations, or discipline of the religious denomination, sect, or church of which it is a part, any religious society, religious order, diocese, synod, or district organization of any religious denomination, sect, or church may, upon written consent and or by an affirmative vote at a meeting called for the purpose of at least 2/3 of its membership, incorporate for the administration of its temporalities or for the management of its affairs, properties, and estates. But take note that these corporations, special corporations, no, religious, tsaka religious corporation, corporation sole, ano ito sila, non-stock ito sila, no? These are not for profit ng mga corporation. Just to manage no the properties, affairs, and estate of the church or the religious society, kaya pwede silang mag-register as a corporation. Okay? One-person corporation is one of the major amendments of the Corporation Code. Because before, you cannot form a corporation if less than 5 yung persons or incorporators. Kailangan at least 5 persons. But with the amendment of the Corporation Code, allowed na ngayon yung one-person corporation. So, a one-person corporation is a corporation with a single stockholder, provided that only a natural person, trust, or an estate may form a one-person corporation. So, kunyari may namatay, pwede nilang gawing corporation yon kasi estate, di ba? Okay, that ends now our discussion for other corporations. So, see you next video.